If you'd like to support this podcast, please check out our Support Us page at asymmetricalhaircuts.com.
Yes, do buy us a coffee on Patreon. That way you also get to hear our special War Criminals Book Club recordings with our fellow international justice reporter, Molly Quell.
He steadfastly insisted that he was guilty, quote, only of aiding and abetting in the commission of the crimes with which he was charged, that he himself had never committed an overt act. And I think I could have written that sentence basically for every single defense of a suspect I have ever covered in any trial in any court for war crimes, genocide, crimes against humanity.
It's often a bit of a riot.
And sometimes it's a serious discussion about books, and sometimes not, and sometimes films. And we'll pick things that portray the worlds of international courts and war crimes.
And it's only on Patreon.
Come find us there.
Asymmetrical Haircuts Justice Update with Janet Anderson and Stephanie Vandenberg.
Hi, Janet.
Hi, Steph.
Oh, well, welcome to another week of people shouting at each other on the internet about international law.
Yeah, it's been a bit weird, hasn't it? I mean, quite tough in some cases.
Yeah, we don't want to belittle what's happening in the Middle East. As we are talking, Israel has bombed Lebanon. There are already hundreds of casualties and thousands have fled and are fleeing, just as thousands fled North Israel while rockets came down.
Yeah, it's all really going to hell in a handcart, isn't it? As this is going on, we're not obviously going to be examining specifically the war, but we thought that we'd try to provide a bit of a public service with an examination of the most recent big development about the potential limits of international humanitarian law with reference to the pager and walkie-talkie attacks in Lebanon, which were really celebrated as this huge example of Israeli prowess by a lot of people, how they managed to devastate Hezbollah's communications, and then condemned on an awful lot of other people's sides as this kind of mass casualty attack which affected children, affected medics, and even the Iranian ambassador to Lebanon.
Yes, and we'll also mention Israel-Palestine in the form of the ICJ advisory opinion ruling being adopted or voted on by the UN General Assembly. You can listen back to the pod we did together with Molly explaining what the advisory opinion actually said. But now the process is that Palestine asked the General Assembly and the General Assembly asked the ICJ for an opinion about the occupation, and the ICJ provided such the opinion, and now it's gone back to the UN General Assembly where they can kind of vote on what to do with this advice from the ICJ.
So again, as always, we end up with a kind of a wither question, a very typical journalist question. So, what next? And we're also going to be mentioning something that we always continue to follow, which is the case of the investigation into Palestine at the International Criminal Court, and that the Israelis have finally produced some kind of a response, which is part of which is public, and it's complaining about the threat of potential arrest warrants. So it's been really busy.
Absolutely. And I see here the script says that I have to do my Stephopedia thing on the pager attack. So there's a lot of background here, so strap in. I have looked it all up and see how Reuters shorthands it, but it's still somewhat of an explanation. So over a 2-day period last week, thousands of pagers as well as walkie-talkies used by Hezbollah operatives blew up in Lebanon, killing at least 39 people and wounding thousands. Now, Hezbollah is a powerful Lebanese Shiite militia group and a political party, very anti-Israel, pro-Palestinian, and an ally of Hamas, but better armed and organized. It's considered a terrorist group in its entirety by the US. The EU says only the armed wing of Hezbollah is a terrorist organization. Now, the attacks done via the pagers and then at the funeral of the people who died by the pagers, walkie-talkies exploded, is widely believed to have been carried out by Israel, or Israel has neither confirmed nor denied its involvement. A lot is unclear about how and when the pagers were weaponized, so they could be remotely detonated. We have investigations into possibly providing these pagers already going on in Taiwan, Hungary, Bulgaria, and Norway. And they're investing their links to the supply chain. I also saw in my scour of what I could say about this that sources have told Reuters in Lebanon that it was the Israeli Secret Service, the Mossad, who planted the explosive in the pagers, but that has not been officially confirmed.
Yeah, I mean, I spend a little bit of my time reading thrillers, and I was just seeing this going on thinking, where am I? Am I on my Kindle or am I in real life here? And then what you see is everybody really arguing on the space that used to be known as Twitter about exactly what the rules are on something like this and coming out with first takes. So what do? Well, I thought, I better turn to Geneva, which is the kind of hallowed ground for international humanitarian law. It's where the ICRC hangs out, and you've got spaces like the Geneva Academy, where people who really know about the dots and the commas in the Geneva Conventions and all the other treaties and so on that surround that help to provide some of the interpretations. So I caught up with Marco Sassoli, who is a former head, I think, of the Geneva Academy, now a professor emeritus at the University of Geneva. And he's also someone who's worked on the ground in conflicts when he used to be with the ICRC. And he's also talked to many, many military lawyers about this stuff. So I thought he was quite an interesting person to pull in for us. I sent him some questions, and I first asked him whether I was really in the ballpark in my assessment. This whole pagers issue is a bit of a complicated one for international humanitarian law.
No, this is indeed, one has to clarify that this is a complicated and controversial, unprecedented case. We shouldn't give the wrong impression that the international humanitarian law never gives clear answers. The settlements are prohibited, the taking of hostages is prohibited, torture is prohibited. But in this case, I think one can have, in good faith, different interpretations, and under some of them, this does not violate humanitarian law, while under others, it does.
Now, of course, we could have just stopped there because that's essentially a summary of what Marco has to say. But I went on to ask him, kind of knowing the basic principles of IHL, that we have these usual issues of distinction and proportionality. What really seemed to be at stake here is precisely what makes a lawful target. And he started off by laying out the full gamut of international humanitarian law reasoning on this.
Well, technically, it depends on the classification of the situation. If there's no armed conflict, this was clearly unlawful. You cannot deliberately kill people. You can at best arrest them and try them for their acts. If there is an armed conflict, it depends whether it's an international or a non-international armed conflict. And this is slightly controversial. It depends on whether Hezbollah belongs to Lebanon. I think there are good reasons to consider yes. And if it belongs to Lebanon, it would, and this is how they classify themselves, be a Lebanese resistance movement. And then all members of Hezbollah are combatants and therefore lawful targets, except obviously medical personnel and the wounded and sick and so on. While if it's a non-international armed conflict, then there's no combatant status. And there, at least the ICRC suggests, and I think this is correct, not every member of an armed group is a legitimate target, but only those who have a continuous combat function. But finally, my feeling is it doesn't make, in this case, an enormous difference whether we apply the law of international or non-international armed conflict. The decisive thing is whether this is a discriminate or an indiscriminate attacks. Indiscriminate attacks are prohibited, And one case of an indiscriminate attack is one which employs a method or means, I think here we have a method, of combat which cannot be directed as a specific military objective. And so, even if most of those targeted by these pager attacks were, between inverted commas, legitimate military objectives in the sense that it is not prohibited to attack them, normally one would say there are too many unknowns in this method because you don't know once you have manipulated the pages to whom they are distributed. Perhaps it will be the child care people who have to be warned by the parents or vice versa and so on. So I would say the Israeli secret services must have had very, very precise information on how and to whom this is distributed. Otherwise, it's unlawful. And this is one of the risks of proliferation and precedent, that in the future, people will use the same thing without having exactly the same information. I don't know what information they had, but apparently most of the people targeted were indeed legitimate targets. Now you can say some were not, like the Iranian ambassador and allegedly medical personnel. So, again, it works only under international humanitarian law if you have incredibly reliable and precise information about how and by whom and under which circumstances these pagers will be used.
Okay, I mean, this continues. Marco went on to outline some of the issues of precision, which is what proportionality can be about. Can you be sure who exactly is going to be targeted by something like the pagers? The reports say that the pagers kind of beat for a few seconds and they were being held up to people's faces. That's why there were so many eye injuries, but maybe they were also being picked up by people's children. But these pagers blowing up were not meant to actually hurt somebody 3 meters away from them. And that's actually quite different from all of the random shelling and bombing. But Marco said that the issue here under IHL, and of course I summarise in pure journalese, actually comes back to whether these are thousands of individual attacks or just one big attack to be assessed.
Now, if it is one attack and certain declarations of Western states when they became parties to Protocol Additional 1 go into this direction because they say an operation must be evaluated as a whole and not every part of the operation. If this is correct, then the fact that also some medical personnel and the Iranian ambassador and so on, who are not legitimate targets, were harmed, can be incidental victims of a lawful attack. I give you an example, and I have done that several times, negotiating about humanitarian law when I went to the Israeli Ministry of Defense and the enemy attacks the Ministry of Defense. Killing me is not unlawful. So if it is an attack as a whole, if I understand correctly the proportions, the number of non-legitimate attacks was relatively minor compared with the number of legitimate targets. While if you consider that each attack has to be evaluated separately, then you must say you cannot justify to kill a pregnant woman because you have killed otherwise with other attacks 20 combatants. I mean, each target must be lawful.
Now, I also asked him about this business of using pagers and kind of inserting some kind of an explosive device in the supply chain and whether that's lawful under IHL, whether this kind of turns them into booby traps and if that's allowed. And again, I summarise Marco's response under IHL. It's more about how they were set off and whether the victim activates them by doing something apparently harmless themselves, or whether they're activated in some way by the person who put the explosive in.
There is a specific protocol to the United Nations Weapons Convention of 1980 on mines, booby traps, and other devices. And here there are two possible candidates. One is if it is a booby trap. And booby trap means any device or material which is designed, constructed, or adapted to kill or injure and which functions unexpectedly when a person disturbs or approaches an apparently harmless object or performs an apparently safe act. Now, some people, including a former British top military lawyer, says, and this depends simply on the facts, if they were first activated by the Israelis and then they actually blew up only through an act of the victim, then this is prohibited because it falls under the booby trap. I must say, without being an expert, my impression was, but perhaps you have better information, that all these pagers exploded exactly at the same time. And therefore, it's not possible that by chance, every one of these victims did something apparently harmless, but I rather deduce that it is the Israelis which made them explode, all at the same time. And some people were on the toilet, and some people were on the phone, and so on. But this is not totally clear. I mean, there are also reports that these were in the pockets, and then people took it out, and they thought it's a message, and then it exploded, and so on. So it could fall under the booby trap. Then there are, still under this protocol, the so-called other devices, which are interestingly defined, means manually emplaced munitions and devices, including improvised explosive devices designed to kill, injure, or damage, and which are activated manually by remote control or automatically after a lapse of time. Now, this would be a good candidate, but the question is, are they manually emplaced? My feeling is that if I sent you such a device by the post, obviously I didn't place them manually with you, so it could be manually emplaced, and then it is prohibited as such, but indeed, it's not so clear, and the prohibition to use other devices in the form of apparently harmless portable objects which are specifically designed and constructed to contain explosive material. Here the question is, but I don't have too much doubt that these are apparently harmless portable objects, because obviously communication materials in all armed forces are something very important. And the other point is where they're specifically designed and constructed to contain explosive material. Originally not, but the Israeli later, if I understand correctly, did it change it. And so I wouldn't have too many doubts about that. So under the prohibited weapons point, the crucial issue is whether this term of manually emplaced has to be taken literally, and then it was not manually emplaced, or whether we have to understand it in the context, and one should make a more serious research into the preparatory works and so on to see why did they limit this to manually emplaced. I mean, I don't still fully understand the logic, but I must say this deserves some research.
Okay, you've done a tremendous, in my view, tour de force there of a lot of the different aspects. But what strikes me is that a lot of this is from conventions and treaties. So what has actually been tested out of all of the things that you were talking about being lawful and unlawful in international courts? I mean, I know proportionality has to some degree, maybe distinction to some degree, but I mean, you say it's an unprecedented and situation. What parallels can we draw? Well, is there anything that you can look back on and say, you should also consider what the judges said in this case at an international court?
This is a very interesting question because it shows basic difference of mentality between common law lawyers and civil law lawyers. And you must accept that in international law, courts don't have the same role than in common law, where they develop the law also. In common law, you have plenty of statutes today. I mean, it's only a few things which are purely regulated by common law. But in international law, I mean, if the treaty prohibits it, we don't need any court having applied this. And Israel is a party to this famous second amended protocol to the UN Weapons Convention, which is rare because Israel is, for instance, not a party to Additional Protocol 1 to the Geneva Convention. But here it is a party. And even if you say that this is a non-international armed conflict, this protocol now applies because there was an amendment also to non-international armed conflict. So somehow I don't need the court, obviously. If there was a precedent where an international, and you must be conscious that courts nearly always, sometimes it's different, like now with the advisory opinion of the International Court of Justice on the lawfulness of the Israeli presence in the West Bank. But normally it's criminal courts, and obviously criminal law is rightly so much more limited than humanitarian law, because there needs to be someone who has the intent and the knowledge that the target is unlawful. So to make a mistake is not a crime, while it may well be a violation of humanitarian law by the state, which did not plan the whole operation correctly enough. But I repeat, to the best of my knowledge, there's no precedent for this, which is, as I said, slightly dangerous because it could be a precedent. And if others do that, perhaps they have less reliable information and so on.
A more general point here. I mean, there's a sense, I would say, amongst people looking at what is happening in Gaza, what's looking Israel and Lebanon, what we're looking at in Sudan, that kind of the basic laws of war are just not being adhered to by many of the parties, and that there's a kind of question mark over whether, and I know all of these situations are different because some are international and some are non-international, some are as a result of some specific action, but there's certainly a sense in that I have reading what is going on at the moment, that does anybody actually pay attention to IHL anymore?
Nearly all parties invoke IHL. Israel always insists with very detailed explanations, which in my view, are legally at the outer borderline, but the main problem is we don't know the facts. And they are quite vague because they say when they destroy something in the Gaza Strip, this was a command and control center. Now, not every Hamas fighter, because there are many Hamas fighters in the Gaza Strip, and they are a legitimate target, is obviously so important to justify to take the risk of killing so many civilians in such a densely populated area. So we would need to know more. But generally, on your question, I would say three things. First, that armed conflicts are obviously not situations very prone to the respect of rules, because the conflict wouldn't exist if the parties were respecting rules. Second, we get an erroneous impression because the media and the NGOs and the international organizations and the tribunals, they focus on the violations. I mean, it would be ridiculous. You wouldn't make with me a podcast about the respect of IHL in this or that conflict. Also, my experience in the field, I started with the International Committee of the Red Cross in the war between Iran and Iraq. And for instance, even the Iraqi of Saddam Hussein, which was a very inhumane regime, but nevertheless, the Iranian prisoners of war were more or less treated in conformity with the Third Geneva Convention. And even in Bosnia, where we had all these violations, which we know about thanks to the Yugoslavian tribunal, I negotiated with a lot of the Bosnian Serb officers who were properly trained in the Yugoslav army. And we had discussions you could have with American, British, Israeli, and so on officers about interpretation of this or that rule. But no one said, we don't care about international humanitarian law.
Okay, big breath from me coming out of that. That was an awful lot to absorb, but it was interesting, at least for me, to have an IHL expert, a teacher, a lawyer, to go through the stuff point by point and to show what aspects they would be considering. What struck you, Steph?
Well, what struck me is that because he lays it out so much detail, you can see how these different kind of good faith interpretations could be applied, and where the real sticking points are of, is it one attack, and is then the goal of that attack enough of a military advantage that it is not indiscriminate, or do you have thousands of attacks, and does every attack have to have the same military advantage? And it becomes much more difficult. These are the kinds of things that we also see with the discussion about shelling in Ukraine, for instance. And so there are these little aspects of IHL that are still debated and are not entirely ironed out in the courtroom, sometimes because we just haven't had so many cases about these types of attacks, sometimes because these attacks use some kind of technology that wasn't there before. And so we really don't know what's gonna happen if they ever come to a court case. So many people can say so many things with such absolute conviction. And I thought it was interesting that he can see that there are people who can say the absolute opposite thing with absolute conviction and be completely convinced that they're right about it. And I thought that was interesting.
Yeah, I mean, on this podcast, we do try to champion some nuance in the sense of having experts say stuff. I would say that overall, I got the impression, if you read carefully, and if I had to journalistically pick out individual sections in order to illustrate a piece rather than, running most of the interview, then I would suggest that he was much more critical and skeptical of whether this all works under international humanitarian law than not. What was interesting for me was his reasoning to kind of get there, to show how you build up the different strands of arguments in order to understand whether this was something that's normal under international humanitarian law. And it really struck me that, this conflict and so many that we've been going through over the last couple of years keep on presenting massive new challenges to IHL, and wondering whether it can really kind of keep up with the new developments.
Another thing that I found very interesting in this discussion about Hezbollah is if you can target every member of Hezbollah as a combatant, and whether under the Geneva Convention, if you're a political supporter of a group that's not taking an active part in the hostilities, you are not a combatant, as I read the Geneva Conventions. But there seems to be also some different interpretations of that, and you saw that also come out very much on the kind of international law discussions about this.
I also found it quite fun that he batted straight back my suggestion that maybe we need to wait for courts to have something to say on this, and asked him what has been said before. And he said, why courts? It's all about treaties. This is how, in fact, international law is run. You come from that common law tradition where you think everything's set by precedent rather than the civil law tradition. But in the back of my mind, there was the question that you had asked me to put to him, which is whether there was, as we know, no immediate jurisdiction for the ICC and very unlikely to be any jurisdiction for any international court. We've previously in The Hague had the Special Tribunal for Lebanon, or just outside The Hague, but in our backyards. And that was dealing with 4 people who were accused of working for Hezbollah in Lebanon in a particular incident where a car bomb was set off. And in fact, those people were found sort of guilty on part of the charges at least. But I assume that, there is no chance, is there, Steph, that the ghost of the Special Tribunal for Lebanon, which we thought that we had fully buried the body in the grave as the sort of, it didn't manage to do much at the time, and it never managed to get hold of the Hezbollah people who were put on trial. It's never going to be resurrected, is it, for this?
No, I don't think so. It was extremely narrow to begin with, and then even in that very narrow mandate, they didn't quite finish what they were doing. But the mandate was that the tribunal was established to try all those who are found responsible for the February 14th, 2005 terrorist attack, which killed the former Lebanese Prime Minister Rafik Hariri and others. And they had a little thing that their jurisdiction could be extended beyond that event to other attacks in Lebanon, but they are very narrow between October 2004 and December 2005. And they have to have evidence to show that those are connected and in a similar gravity to the attack on Hariri, or the attack that killed Hariri. So I see no resurrection. There's not going to be a zombie resurrection of the STL. I think what might be possible was because the STL was also partly based on Lebanese law and the laws against terrorist acts in Lebanon, that maybe if this ever becomes a case for national courts, that they might use some precedent and some insights from that case into this. But that would be assuming that Lebanese politics would develop in such a way where it would be possible where this would be a case. And that's more political.
So we're not going to expect that to happen very soon. But we did promise right up at the top of the podcast that we would also cover some other things apart from this pager attack. And we need to wrap the podcast up. So we keep on monitoring the International Criminal Court, and there come sort of scares or information, or, we wonder when might some arrest warrants, which have been asked for by the Office of the Prosecutor against the leadership of Israel and the leadership of Hamas, when might those be decided on by the judges? Steph, would you like to predict?
Not anymore. I had thought that they might be imminent. And so I've been on kind of high alert for the past 2 weeks, because I kind of figured out it usually takes about 3 months. We're about 4 months, but they had the Amici Courier, so they need a little more time. There are new judges, 2 of them, so maybe they also need a little more time. So from this moment, you can maybe start expecting something. Then we had some kind of diplomatic sources and rumors were kind of flying that it might be coming out soon. So I was very much on high alert. But then in the meantime, got the news that Israel submitted a challenge to the ICC, a legal challenge.
Okay, so what did you have to say about that for Reuters? What's the quick and dirty on that?
The quick and dirty on that, this was the Reuters lead. Israel submitted on Friday formal challenges to the International Criminal Court over its jurisdiction and the legality of arrest warrant requests against Israeli leaders for their conduct of the Gaza war, the foreign ministry said. And then I added, Israel's filings might further delay a decision on the warrants requested in May against Israeli Prime Minister Benjamin Netanyahu and his defense minister Yoav Gallant.
So I sent a quick message to Adil Haque of Rutgers University in New Jersey and asked him whether he could provide us with his critique of Israel's approach.
Israel says it has submitted its official challenge to the ICC's jurisdiction, and that one of its two legal briefs outlined the ICC's manifest lack of jurisdiction in the present case. There are two problems here. First, Article 19(2)b of the statute permits a challenge from a state which has jurisdiction over a case. However, under the court's prior decisions, a case begins with the issuance of an arrest warrant or a summons to appear. So Israel cannot make a challenge before arrest warrants are issued. Second, Article 19(2)b does not permit a challenge to the court's jurisdiction. It permits a challenge to the admissibility of a case on the ground that the state is investigating or prosecuting the case or has already done so. To my knowledge, Israel is not investigating or prosecuting the same individuals for substantially the same conduct, so this provision does not apply. In contrast, challenges to the court's jurisdiction may only be made by an accused or a person for whom a warrant of arrest or a summons to appear has been issued, or by a state from which acceptance of jurisdiction is required under Article 12. So it seems that Israel cannot challenge either jurisdiction or admissibility under Article 19. Now, Israel says it has filed a second legal brief detailing, quote, the ICC prosecutor's wrongful breach of the court statute and the principle of complementarity. This may refer to the argument made by some interveners that the prosecutor should have opened a new investigation into the Gaza war or sent Israel an additional notification that his ongoing investigation had expanded from its original scope since 2021. The basic problem here is that Article 18 of the statute does not require anything like this. Once an investigation is opened and the relevant states are notified, the investigation will follow the evidence where it leads and change its focus as the situation itself changes. To rule otherwise, the court would have to make up rules of its own invention to regulate the prosecutor's investigation, something courts tend to avoid.
So does that provide some clarity, Steph, or do you think it still leaves maybe something a little bit open to be debated?
Yes. Well, the problem is it leaves a lot open to be debated, and it leaves a lot generally at the ICC is also open to what the judges will do with it. And these judges have already shown that they were willing to entertain these Amici Curiae submissions, that they were looking at these things, and they're like seem to be taking extra care to take in all the viewpoints. So if I would have to gamble on it, I would say that they have to engage with this legal filing, but also they might want to engage in some depth with it because they really seem to be wanting to dot every I and cross every T before they make a decision to make it sure that it's grounded as possible. So my prediction is that this has pushed kind of a decision that they would announce on arrest warrants further while they have to deal with this.
Okay, but let's just add in one other element to this podcast before we let our listeners go. We are also monitoring the effects of a recent advisory opinion by the International Court of Justice. I mean, the court is just so active right now, and this is not the same as the investigation by the ICC into Palestine, but it is connected. We'll come to that right at the end in the sense that it's at least about the same part of the world. And everybody and their mother have been asking the courts for advisory opinions. If you want to, you can listen back to the pod that Molly Quell helped lead us through, sort of what all the advisory opinion applications are before the court at the moment. And we're gearing up, aren't we, for the big hearings on the big climate question, advisory opinion hearings that's been also asked by the General Assembly on behalf of Vanuatu.
Yeah, and that's been very thoughtfully planned at the same time of the annual meeting of the ICC. So my world is going to get as busy as it possibly can in that period.
Yeah, cue lots of mistaken images from two different courts in the media, lots of confusion and lots of misunderstanding about what actually gets decided where. Oh, well. But on these advisory opinions, there's kind of a line that comes out to suggest that they don't count because the ICJ has no kind of enforcement.
But that's the same for all ICJ. It has no enforcement. What we tend to say is that ICJ rulings are binding and advisory opinions are not. And advisory opinions are more to lay out the state of the law right now and tell states what they should be doing.
So we asked Nada Kiswanson, who's a Palestinian international lawyer. She's worked extensively on Israel's occupation and edited the book Prolonged Occupation in International Law, whether she could help us to understand what the meaning is of the most recent vote at the General Assembly, which basically, as far as I was concerned, by quite a majority said that the advisory opinion should be acted on. And she sent us a series of small voice notes.
The adoption of the UN General Assembly resolution of 18 September, the first ever tabled by the State of Palestine, is important because through it, most UN member states acknowledge, welcome, reiterate, and support the findings of the International Court of Justice advisory opinion, including then the findings that Israel's presence breaches Palestinians' right to self-determination and the prohibition against the acquisition of territory by force, thereby rendering Israel's presence illegal and compelling Israel to leave the Palestinian territory rapidly and withdraw all its settlers. The UN General Assembly does not have the enforcement powers of the Security Council, but it is the most representative body of the UN, and the adoption of the UN General Assembly resolution indicates a strong global shift in understanding and policy towards Israel's actions and presence in the Palestinian territory.
We also asked Nada what effect she thinks the UN General Assembly vote has. And with so many countries abstained, does that show anything more than the usual division between those who support Israel and those who don't?
You are right. 43 UN member states, including countries like Sweden, Austria, the Netherlands, Ecuador, and Guatemala, abstained. And to me, this suggests that some states are struggling to align their political views with the World Court's legal views. For almost 6 decades now, states have conveniently shaped their politics towards Israel and Palestine around an understanding that Israel's occupation is in itself lawful, and therefore the situation is in waiting for a political resolution. The International Court of Justice shatters this fundamental understanding when it declares that the sustained abuse by Israel of its position as an occupying power through annexation and an assertion of permanent control, and its continued frustration of the right of the Palestinian people to self-determination, violates fundamental principles of international law and renders Israel's presence in the occupied Palestinian territory unlawful. In my view, the court's decision cannot but force states to reset their approach to and definition of their desired two-state solution. Remember that, for example, the EU repeatedly called on Israel to end its settlement policy and construction, but added that the fate of settlements already established and settlers already present in the occupied Palestinian territory are to be negotiated. There's no legal justification for that position anymore. What may also be hard for states to swallow is the court's opinion that all states, international organizations, and the UN itself are under an obligation not to recognize as legal the situation arising from Israel's unlawful presence, and not to render aid or assistance in maintaining the situation created by Israel's unlawful presence. This opinion really confirms and adds to many other resolutions, decisions, and positions that states would be in breach of their own obligations if they continue to support Israel's conduct and presence in Palestine.
As Benefa Noroji, who's the president of the Open Society Foundations, wrote in Just Security, it really feels like the judges have thrown down a challenge to states with that advisory opinion, and this General Assembly resolution has kind of reinforced that. it's really asked states, how committed are you to international law? Are you using a single standard or double standards? Do you invoke international law when you want to and kind of ditch it when you don't want to? And in the resolutions, states who put that resolution forward really pushed the conclusion that all states, all international organisations, and even the UN itself are under an obligation to recognise Israel's presence in the occupied Palestinian territories as unlawful and not give any aid or assistance in maintaining that situation. So we asked Nada right at the end, this kind of nerdy, as I keep on saying for myself, Janet in her undergraduate mode, can you help us get our heads around all of this? To wrap it all up, how does this advisory opinion add to or reinforce, quote, customary international law, unquote? Is it just because is that the way it works, that it pulls together all the treaties and UN resolutions?
What we need to be aware of is that the court's opinion is firmly based on already established customary international law and treaty law. Its findings are not a result of conjecture or a patchwork of state practices. The court is not creating law in this instance. It's brilliantly reaffirming it and applying it to Israel's conduct in the Palestinian territory.
All of that still leaves a lot open for us to carry on speculating about. For example, will the ICC Office of the Prosecutor address occupation in its investigation? Will it address settlements and the legality of settlements? Will it address apartheid as a crime against humanity?
Yeah, I think the kind of knock-on effects of this advisory opinion will carry on from one court to the other, just to be very confusing for fellow journalists. I was also thinking about what we have to cover in domestic courts about giving aid and sending arms to Israel, and some of the cases that have come up about European companies being involved in the building of settlements. So I think, as usual, we'll end the podcast with our usual, our job will continue for quite some time.
Yeah, we will keep covering the ramifications of this advisory opinion and also the one to come on climate, and see what states really do with this in practice, because that is always the big question of international law. We have this, but what does it mean in practice? So here we are again.
Yeah, here we are again.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie van den Berg. This episode has been recorded at home, but we'd like to give a shout out to our regular host, Humanity Hub in The Hague. Music is by audionautics.com, and you can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.